Hello, welcome to our webinar this morning, and thanks for joining us today to discuss what the Supreme Court's recent decision on the Impact Assessment Act means for federal climate policy. My name is Alexis Stoimanoff, and I'm the Communications Director at West Coast Environmental Law. And I'm calling in today from the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations, also known as Vancouver. We also have colleagues and attendees joining from different parts of the country. So if you'd like, please feel free to say hello in the chat and let us know where you're joining from as well. Today's webinar is the second session in our series about assessing the impact of the Supreme Court's opinion, which found that the federal government overstepped its jurisdiction in parts of the Impact Assessment Act. In our first session, we discussed the details of the decision and some of the key takeaways for the environment more broadly. And today we're going to be taking a deeper look at the implications of the decision when it comes to federal climate action. So we are very happy to have three legal experts presenting today, all of whom have participated in Supreme Court case as interveners. First, we have my colleague Anna Johnston, staff lawyer and West Coast Environmental Law's lead on this file, and she'll be presenting an overview of the court's opinion and her perspective on the next steps. Then we'll hear from David Wright, associate professor at the University of Calgary Faculty of Law, who will elaborate on the court's findings regarding greenhouse gas emissions and what that means for climate in assessments. And then next, we'll hear from Anna McIntosh, staff lawyer at Ecojustice, who will be getting into some of the implications of the opinion on existing and proposed federal climate policies. So the webinar is going to run for about an hour and 15 minutes, and we'll have time to get to your questions after we hear from our three panelists. Please feel free to submit your questions using either the chat or the Q&A function at the bottom of your Zoom window, and we'll reserve all the questions to discuss later during the Q&A. Finally, I should mention that the webinar is being recorded and will be circulating the recording after the event. So I think that's it for housekeeping, and with that, I will pass it over to Anna.
Great. Thanks so much, Alexis, and good morning, everyone, or good afternoon, depending on where you're joining us from today. I'm zooming in from the unceded territory of the Algonquin and Anishinaabe peoples here in Ottawa, and I'm so glad to be presenting on the second webinar of our series about the Impact Assessment Act reference case. So in my presentation, I'm going to give an overview of the Supreme Court of Canada's majority opinion in the case. If you want a more detailed analysis, you're welcome to check out my blog by scanning that QR code on your screen. I'll start just with some quick background about the Act, and then I'll discuss the court's opinion. So I'll explain both what the majority said Canada can do when it comes to impact assessment and why it found that the Impact Assessment Act goes beyond what Canada can do. And then I'll wrap up with what happens next, both in terms of amendments and what the government says will happen between now and when the Act is brought into conformity with the Supreme Court's opinion. I won't go into detail about the climate aspects of the opinion. David is going to talk about what the majority's opinion means for assessing climate in federal assessments in the future, and Anna McIntosh will talk about what it means for federal climate policy more broadly. So first, the Act. It was enacted in 2019, replacing the Canadian Environmental Assessment Act 2012. It's our fourth federal assessment law in Canada. And in fact, this year marks the 50th anniversary of doing federal assessments in Canada. So fundamentally, impact assessment is an information gathering and planning tool that's aimed at understanding and avoiding and mitigating the adverse effects of projects before they occur and enhancing their benefits. The Impact Assessment Act is designed to only apply to major projects, which the federal government has determined amounts to approximately 10 to 12 projects per year that have the most potential for adverse effects in areas of federal jurisdiction. Those projects are designated either in regulations according to their type and their size, or through an exercise of discretion by the minister following the request of a member of the public or an Indigenous nation or community. And while the Act sets out a long list of factors to consider in assessments, at the end of assessments, the minister or governor in council decides whether the adverse federal effects of the project are in the public interest in light of the assessment report and 5 enumerated factors, including the extent to which the project helps or hinders Canada's ability to meet its climate commitments. So what did the court say? First of all, I should note that this is just an opinion. It was a reference case, meaning that the Supreme Court's findings are not technically legally binding on the federal government. It is, though, customary in Canada for governments to respect the opinions of courts, and the minister has said that Canada will respect this one by amending the Act. So a 5-judge majority led by Chief Justice Wagner found that the Act is unconstitutional in part. So the majority divided the Act into 2 schemes. One being sections 81 to 91 that set out minor environmental assessments of projects that occur on federal lands, projects that are federally funded, and Canadian projects that occur outside of Canada. And the second being the designated project scheme that applies to those major projects that I described earlier that are designated through regulations or by the discretion of the minister. So the majority took no issue with that first scheme, the mini environmental assessments of federal projects. It's the designated project scheme that it identified some issues with that ultimately render the Act unconstitutional. And I should, of course, note that there is actually a third scheme in the Act governing regional and strategic assessments. The majority didn't mention that scheme at all. So because they didn't find that regional and strategic assessments are unconstitutional, those provisions also remain as constitutional. And then there was a 2-judge minority that found the entire Act to be constitutional. Before I get into why the majority found the designated project scheme unconstitutional, I would like to note that my main takeaway is that the opinion actually probably won't change a lot about the scope and application of federal assessments federally. There are some implications, in particular for climate considerations, but the majority was really concerned that the Act permitted authorities to exercise their discretion in unconstitutional ways. And the agency and the minister have said that they always intended to exercise their discretion in the way that the majority said was constitutional. So the practical implications of this opinion might not be quite as big as some of the headlines suggest. And the court did give some good affirmations about the scope of the federal power to conduct environmental impact assessments. The majority rejected the argument that the federal government can't assess projects or say no to the adverse effects on areas of federal jurisdiction. So it confirmed that Parliament can require natural resource projects to undergo federal assessments. The majority just found that Parliament needs to fix a few things in this law to make sure that the assessment regime is properly focused on federal matters. So it took no issue with how projects are triggered. It upheld the project list approach and actually held that you don't need to prove that a project will have adverse effects on areas of federal jurisdiction to trigger an assessment. The majority found that there only needs to be the potential for federal effects in order to require a project to go into an assessment, and actually called this a low jurisdictional threshold. It's an important win, not just for the federal government, but also for the provinces, because it allows assessments to be triggered early before proponents have had to conduct comprehensive studies, which helps not only make assessments more effective, but it also helps align federal and provincial environmental assessment processes, and it fosters that one project, one assessment goal through harmonization, because when the federal and provincial governments are able to trigger their assessments at the same time, they'll also be better able to harmonize their assessments. So the majority also said that there's no constitutional limit on what authorities can consider during assessments, and upheld that long list of factors set out in the Act. And it confirmed that Parliament can indeed regulate the federal aspects of natural resource projects, including by saying no to adverse effects on areas of federal jurisdiction. So these are important findings, and they're why I consider this opinion to be overall more of a win than a loss for Canada. But it did ultimately hold that the designated project scheme is unconstitutional. Essentially, the majority's concern was that the Act isn't sufficiently focused on federal matters. So Parliament can enact environmental assessment legislation. The majority can confirm that, but it said the legislation needs to be primarily focused on the regulation of federal matters that are assigned to it under the Constitution, things like fisheries and navigation and migratory birds. While the Impact Assessment Act did make attempts to focus on federal effects at key junctures in impact assessments, ultimately the majority found that the act goes beyond just regulating federal matters. And it found so for 4 reasons. So 4 problematic aspects of the act are the definition of federal effects, the prohibition provisions in the act, the agency's screening decision about whether a designated project requires an assessment, and the public interest decision. And I'll go into each of those in turn. So the definition of federal effects. The Act defines federal effects as including all changes to things like fisheries and navigation, migratory birds, as well as effects arising in one province and occurring in another, and all changes to the social, economic, cultural, and health conditions of Indigenous peoples. The majority said that definition overshoots actual federal effects. And one of its concerns, of course, is in the definition that captures greenhouse gases, which Dave will explain in more detail in his presentation. What I'll note here is that the majority also said that the definition captures too many changes, essentially, respecting Indigenous peoples. So the majority said that the federal constitutional power over Indigenous peoples and lands is really about their well-being, ensuring the well-being of Indigenous peoples. And the majority found that this definition can capture any non-adverse changes and any trivial changes that don't actually have much to do with the well-being of Indigenous peoples. And so for that reason, the definition is overly broad. It also questioned whether the federal power over migratory birds extends as far as Canada was claiming it does. What the majority said was the federal power over migratory birds does cover the things that were in the original Empire Treaty that Britain entered into with the US, but it may not include the broader scope that was brought in through updates to the Migratory Birds Convention by the Canadian government many decades later. And so just a few areas of overbreadth of the definition of federal effects. The second main issue that the majority took was with the prohibition provisions, which prohibit proponents from doing anything that might cause federal effects. So cause is the key word here. The majority's opinion on the prohibitions is really closely linked to the issues that it found with the definition of federal effects, which again includes all changes. So what the majority said is essentially the federal government can't prohibit any changes to any areas of federal jurisdiction. It has to focus on prohibiting the adverse impacts of a project on those areas of federal jurisdiction. So tightening up the language of the prohibition provisions to simply bar adverse effects on areas of federal jurisdiction that aren't authorized shouldn't be too big of a fix to make. The third issue the majority took was in the agency's screening decision about whether or not a designated project actually needs to go into a full impact assessment. So right now in the planning phase, the agency has to make that decision, that screening decision, by considering a few factors that are listed in the law, one of which is possible adverse environmental effects. The majority said it's not enough to just put that consideration on equal footing with other considerations. The possibility or potential for adverse effects needs to be a priority consideration when the agency is making that screening decision. And that, again, that's how the agency said it was already applying the act. And so amending Section 16 to bring that screening decision into compliance with the majority's opinion shouldn't really change much on the ground. And finally, and this is where the decision does get problematic for Canada and for climate, the majority took issue with the public interest decision. So as I mentioned at the beginning of my presentation, the Act requires the Minister, Governor, and Council to decide whether the project's adverse federal effects are in the public interest. While on its face, this decision is about federal effects, the majority said it doesn't actually pass the sniff test. It found that the intention and the effect of this decision provision go beyond just the regulation of federal matters and is an unconstitutional attempt to regulate provincial matters. And it found that for two main reasons. First, that some of the factors that the minister has to consider when deciding whether the federal effects are in the public interest are actually about the whole project, like whether the project helps or hinders Canada's ability to meet its climate commitments. And so the majority took this language to mean that the decision really is actually about the projects and not just their federal aspects. And second, the majority found that federal decision makers should be able to consider the non-federal benefits of projects, but not their non-federal adverse effects when deciding whether the federal effects are in the public interest. So in other words, for example, if a minister is deciding whether adverse effects on fisheries are in the public interest, it can consider things like jobs, but it can't say no to the fisheries impacts in light of non-federal effects like local air pollution, for example. It said doing so would turn the decision to actually being about the non-federal effects. Instead, decision makers have to focus on the federal aspect. So what now? Because, as I mentioned, the court's ruling is just an opinion, the Impact Assessment Act isn't immediately rendered invalid. It remains in force. The federal government has said that they're going to amend it as quickly as possible. And in the meantime, the government has issued guidance, interim guidance to apply. And that guidance says that the agency will review all assessments that are already in the hopper to make sure that there's clear jurisdiction, federal jurisdiction for each. And the agency will ensure that that Section 16 screening determination that it makes at the beginning of assessments does prioritize the focus on the potential for federal effects. The minister has said that he'll not exercise his discretionary authority to designate new projects, but projects that are listed in the regulations that are designated through the regulations presumably still will need to comply with the law. And so any new projects that are in those regulations will have to come into the process, although it isn't clear whether officials intend to enforce those rules. And then finally, regional assessments that have already been announced will continue. And just in closing, next steps, I'm sure that the agency and the minister and their lawyers are busy assessing the opinion and thinking about amendments. At this stage, I can only speculate about what those amendments might be. In my view, they should be relatively straightforward and they can be limited to just those 4 problem areas I identified. So the definition of federal effect, the prohibition provisions, the screening decision, and the decision-making provisions. Usually we'd be looking at a fairly lengthy process, but it may be possible for Parliament to introduce amendments in the spring and potentially even have them be passed before Parliament rises for the summer break. And in the meantime, as I noted, the Act remains in force. And overall, in my opinion, this was not the ruling that Alberta was hoping for. It really was just the court's attempt to ensure a workable and balanced federalism in Canada that some tweaks to the law should satisfy. So with that, I will conclude my presentation. Thank you very much. And I will pass it on to David Wright.
Thanks, Anna. Just cue things up here. Can folks see that? I actually can't see anyone at the moment. Just give me a verbal, yes, I can see it if anyone. Alexis?
Yeah,
Working.
you are good, Dave.
Good. Can you see the entire slide? It's not cut off at all. It is on my screen for some reason.
It is a little bit on the right.
Okay.
Yeah, Dave, I think your second slide should be good from the last time. Just the first slide is cut off, I think.
Okay. Thank you, Anna. Okay. Hi, everybody. Great to be with you. Thanks so much for the invitation, Anna and Alexis. It's great to be part of this panel. We are trying to keep our comments fairly brief and relatively high level so that we can have lots of time for two-way discussion, questions, and so on. So I will try to keep on track. I'm going to do about a 30-second look back, and then we'll get into what the majority said, what the majority really means in real terms, and then what's next. So just a quick look back. Anna didn't mention this, but of course, consideration of greenhouse gas emissions and climate change dimensions has been part of federal assessment for decades. But it really was the Wild West. There were no minimal explicit rules and guidelines as to how to take such things into consideration and then how they factored into decision making. So the Impact Assessment Act was really rightly viewed as an attempt to bring order to that Wild West context. As part of the broader Better Rules initiative, folks might remember during the development of C69, there was a lot of chat about this creating better rules. Better rules came along, arguably, and the reaction, at least from the oil and gas sector, was thanks for the rules, we hate them, or at least from political channels in Alberta, and that's what led to the reference case. So nothing new. It was an attempt to bring order, and now we've got a little bit more clarity, but not total clarity. So let's look at what the majority said, and this builds on Anna's really helpful starting point. So first of all, there are no constraints on the scope of the assessment phase. What this means for greenhouse gas emissions is there's really no constraints on the extent to which greenhouse gas emissions, climate change impacts can be factored into the assessment phase. Starting point is section 22, and that can stand. I don't anticipate there to be any amendments to that part of section 22, and perhaps no amendments to section 22 at all. And therefore, for those of you that are familiar with this space, much of the strategic assessment on climate change, i.e. the guidance and the technical guidance, at least to the extent that it pertains to the planning phase and assessment phase, is probably fine. No major changes needed. But then federal authority does narrow from there, as Anna teed up. So the majority approaches the greenhouse gas emissions dimension primarily through its discussion analysis of the definition of effects within federal jurisdiction. And they hone in on the notion of just a change and find that it's too broad, as Anna said. And interestingly, though, the majority really focuses on the molecules, like the greenhouse gas emission molecules, not the impacts of those molecules. And so the majority finds, paragraph 184, that the regime allows projects to be designated, assessments to be required, and public interest decisions to be made on the basis that a project emits greenhouse gas emissions that cross provincial and national borders. Now, setting aside the science as to whether or not greenhouse gas emissions even cross borders, they more commingle. That's where the majority landed. They characterized it as astonishing breadth of that provision. And they said that this is problematic in terms of triggering and decision-making on the basis of greenhouse gas emissions. From there, they reiterate that there's no plenary federal constitutional authority to regulate greenhouse gas emissions. This much we know. And then they really point the finger straight at Canada and say, Canada, you made your submission saying that you were not relying on greenhouse gas emissions as an anchor, yet if you look at the context and submissions, you are attempting to do precisely that, and they characterize it as an end run around this court's recent national concern jurisprudence. Furthermore, they say Canada has made no attempt to apply the clarified national concern framework as set out in the carbon pricing reference or to lead any evidence on which to base the recognition of a new and broader matter of national concern. So that's what the majority says, but they stop there. And that's really significant for the greenhouse gas emissions dimension, because they only acknowledge the absence of that legal argument. And in fairness, that meant the court really didn't have a lot to go on to make a finding that this was fair game in terms of triggering and decision making. And so the majority does not say that this is unavailable. And so really, this is an area of lingering uncertainty. So what does all this mean? Well, it means that the door is wide open for consideration of greenhouse gas emissions and climate change in the assessment phase. I think you can argue that it could even be expanded. So, for example, right now, downstream emissions are not required within the federal IA regime. That could change for the purposes of the assessment phase. For example, there could be new rules that require, it's legally permissible, constitutionally permissible for the federal government to have rules requiring analysis of downstream gas emissions. They just have to make sure that's not taken into consideration in final decision-making for now. But it also remains open to the government to make the arguments to provide a legal basis for greenhouse gas emissions to be taken into account for triggering and decision-making purposes. And so the option is on the table for the federal government to put forward amendments that provide this legal basis and satisfy the applicable legal test, namely the national concern branch of the POG power. For now, though, this is in question. So this is perhaps the most significant area of lingering uncertainty in the wake of the Supreme Court opinion. And so it's really now or never. And the federal government is at this crossroads. One way I've been thinking of it is it's a go big or go home moment for the federal government. And so that leads to the question of what a go big, or choose your metaphor, sticking with the plan, what that looks like. So first option would be to present the legal argument that there's a basis under the residual POG power. And so you'd see amendments that keep greenhouse gas emissions implicitly as a basis for triggering the regime and for decision-making backed by this robust POG argument. So like Anna, I also have a blog post on this, and I'll send the link to the folks at West Coast Environmental Law. But without going too far down the rabbit hole, and much more rigorous analysis is required. This is just preliminary thinking, but an amended definition could look something like this. Effects within federal jurisdiction means with respect to a physical activity. And here's the new part: a significant adverse environmental effect that would occur in a province other than the one where the physical activity or project is carried out. So keep in mind, this is the transboundary effects aspect of this definition. And this introduces a few things. So it brings back that significance threshold, which the majority actually endorses, for example, in paragraph 193, and focuses on transboundary harm. Right. So where the majority took this molecules approach to interpreting this provision, this kind of removes the ability to take such a view and places the emphasis on significance and transboundary harm. The actual matter for the purposes of the national concern branch could be something to the effect of significant adverse transboundary impacts from the greenhouse gas emissions of major natural resources and infrastructure projects. So again, that creates this threshold that makes the matter potentially as narrow and specific as it needs to be to pass that test. Having said that, it's an untested legal argument. And there are challenges in passing the POG test, especially the notion of the scale of impact of this type of national concern matter on provincial jurisdiction. There's another potential argument too, and these are not mutually exclusive. So first one, go big option one was POG. Go big option number two is to use enumerated heads of power. And these would see similar amendments, but the greenhouse gas emission trigger and basis for decision-making would be based on existing heads of power. And so this would be on the basis that a proposed intra-provincial high emissions project, for example, the elephant in the room, an oil sands mine or in situ oil sands operation, could have adverse effects on enumerated powers, federal areas of federal jurisdiction, such as fisheries, navigation, and the rights and interests of Indigenous people. Again, this is an untested constitutional law argument, but if you look at the in-our-face climate change impacts, you can see that there are areas of federal jurisdiction being impacted frequently. Just look at the wildfires across the country this year, especially up north in Indigenous territories, sea level rise, floods, and so on. And so the counter to that, of course, is this long, decades-old argument that we're just one project. We are not causing significant adverse environmental effects. But you see courts around the world finding ways to neutralize that argument. And even the Supreme Court of Canada, in the carbon price reference, said that individual provinces and individual sources of emissions can cause measurable harm and may have tangible extra-provincial effects and contribute to global climate change. And in saying so, they actually cite an environmental assessment case from Australia. So it's kind of surprising that in this environmental assessment context, they didn't try to take that step. Granted, they didn't have the arguments from the parties to make that. And this addresses some of the concerns that were raised in the actual hearing. So there was an interesting exchange with Justice Rowe where he cited home heating, which is in the news for other reasons right now. But what the intention of the proposed amendments that I put forward make it clear that this isn't about household greenhouse gas emissions, right? This is about the very largest projects that are clearly of national significance. So just to reiterate, options 1 and 2 are not mutually exclusive, but there's still an open question as to whether or not these really tame a key concern of the court, which is that Trojan horse argument. And you see the court concerned with the federal government regulating the entire project using a relatively narrow head of power to regulate the whole project. And so this is where further analysis is still required. I think a number of us are still thinking it through. So quick graphic depiction before I wrap up. Where are we now? Well, the impact of climate change on the project, think melting permafrost, that's fair game. Impact of the project on climate change is fair game in the assessment phase. Impact of the project on climate change in the triggering stage is unknown, but there's that question mark there because there are still available legal arguments potentially, and similar for the final decision making. And I just include on this slide the sustainability aspect of the regime because really we're in a similar situation. So it's obviously fair game for the assessment phase, but up in the air for the decision making phase. And so final comments, the notion of a climate test, I would characterize that as knocked down, but not knocked out at the moment. It's really up to Canada to pick it up off the mat and carry it on. And it really is now or never. So it's attractive to keep this, from some perspectives, it's attractive to keep this in the federal regime, but it would rely on these untested legal arguments. And there's an open question, and this kind of sets Anna McIntosh up for her talk. There's an open question as to the value of greenhouse gas emissions in federal assessment and whether or not it's better to place the emphasis on the other tools and levers that the federal government has at its disposal to address and achieve the kind of the greenhouse gas emission reductions that we're seeking to achieve, that the country is committed to, and that's what the graphic depiction is at the foot of this slide. So I will leave it there. I don't have a QR code like Anna. That was really impressive. But here's a snapshot or a screenshot of the blog post that captures most of this. Thanks very much.
Okay, great. Thanks, Dave. Thanks, Anna. I'll just take a moment to share my screen. Okay, so that should be good. Let me know if there's any concerns there.
Looks good.
Great. So I've been tasked with assessing the implications of the IEA reference for federal climate policy writ large. And in short, other than the IEA itself, the IEA reference doesn't have immediate implications for federal climate measures, such as the clean electricity regulations, the oil and gas emissions cap, or carbon pricing. These other measures either rely on different heads of power than were relied on in the IEA reference, or have already been upheld by the Supreme Court of Canada in the case of carbon pricing. That said, the Supreme Court has made clear that they're not willing to give the feds a pass on all measures, all legislation relating to climate change. Following the carbon pricing reference decision, some people thought that the Supreme Court was sending the feds a message that they would uphold any federal measures relating to climate change, recognizing that this is an existential threat. But the IEA reference confirms that this is not the case. This will likely embolden the provinces and industry in bringing challenges to other federal climate measures. And the Supreme Court decision also leaves some uncertainty regarding when the federal government can regulate GHG emissions or not, as Dave's presentation has demonstrated. So we can expect more litigation as courts sort that out. So Anna's presentation has already made this clear, but I just want to affirm again that the federal government continues to play an important role in regulating the environmental impacts of natural resource and electricity sectors, including with respect to greenhouse gas emissions. There's a lot of rhetoric from people like Danielle Smith suggesting that the Supreme Court found that only the provinces have jurisdiction relating to anything associated with natural resource development or electricity generation. But in fact, that's not what the Supreme Court said at all. The Supreme Court specifically stated that the fact that a project involves activities primarily regulated by the provinces does not create an enclave of exclusivity, and even a project primarily within provincial jurisdiction may cause effects that the federal government can properly legislate. That's at paragraph 142. So the Supreme Court just said that the federal government has to focus more closely on effects and matters within its own jurisdiction. Okay, here we get a little bit legal, but I hope it'll be helpful. So I've set out here some of the federal and provincial powers provided in the Constitution Act, 1867. Federal powers, of course, on the left, provincial powers on the right. And I've curated this table to focus on federal jurisdiction over greenhouse gas emissions specifically. So what the IEA reference decision was concerned about, and what Dave was also just talking about, was the scope of federal jurisdiction over transboundary impacts, which I've highlighted in yellow, and I've added an asterisk indicating that the scope of this power with respect to GHG emissions is currently unclear. But this is only one of different heads of power that the federal government can rely on to regulate greenhouse gas emissions. The feds can rely on the criminal law power in section 91(27) of the Constitution. And in fact, they already rely on this power extensively to regulate greenhouse gas emissions, as I'll explain in the next slide. They can enact carbon pricing legislation, In the carbon pricing reference, the Supreme Court confirmed that the federal government has jurisdiction to establish minimum national standards of GHG price stringency as a matter of national concern. And finally, there's the national emergency power, which allows Parliament to enact legislation that would otherwise interfere with provincial powers if it's clear that it is doing so in response to an emergency and the legislation is temporary in nature. One reason that I mention this power is because Justice Brown, in his dissenting opinion in the carbon pricing reference, found that Parliament could rely on the national emergency power to enact climate measures given the urgent and existential nature of this threat. So I have a couple of slides here on the criminal law power, the federal head of power found in section 9127. And the criminal law power is a very important source of federal power over the environment. It's been so since the seminal 1997 case of Hydro-Quebec, where the Supreme Court upheld the federal scheme for assessing and regulating toxic substances under the Canadian Environmental Protection Act, or CEPA. So in 1997, the Supreme Court found that the federal government could assess and regulate toxic substances under CEPA. And then in 2005, Canada listed the GHG emissions targeted by the Kyoto Protocol as toxic substances under CEPA. And since then, Canada has adopted numerous regulations limiting greenhouse gas emissions under CEPA. For example, the reduction of CO2 emissions from coal-fired generation of electricity regulations, which implemented Canada's phase out of coal-fired electricity generation by 2030. And it's worth noting that, like the clean electricity regulations and like the oil and gas emissions cap, these have been measures that have targeted a particular sector, even though the underlying focus of these regulations is clearly on limiting greenhouse gas emissions. These three regulations that I've listed here, they haven't been constitutionally challenged, but they suggest that it is accepted in Canada that the federal government has jurisdiction to regulate GHG emissions, even from specific sectors, like the electricity sector or the upstream oil and gas sector. There has been one legal challenge to greenhouse gas regulation under CEPA, and that was a challenge brought by Syncrude to CEPA's renewable fuel regulations, which prescribe minimum renewable fuel requirements for all producers and sellers of diesel fuel in Canada. So the Federal Court of Appeal upheld those regulations and specifically confirmed in that case that the federal measures aimed at reducing greenhouse gas emissions under CEPA can be valid criminal law. So it seems clear that we can expect litigation on the clean electricity regulations and or the oil and gas emissions cap. Alberta has certainly strongly signaled its intent to litigate, And at this point, we're also dealing with an old precedent regarding the scope of the federal government's criminal law jurisdiction. Hydro-Quebec is from 1997. To clarify, there have been other criminal law cases, but with respect to environment, we're still looking back to Hydro-Quebec, the Supreme Court decision. So what I've done here is laid out basic elements of the criminal law test, just to give you a sense of the issues that will be in play in this litigation and how the federal government might be able to insulate itself against legal challenge. Not providing legal advice here, though. So the criminal law test is quite broad. It only requires a prohibition, a penalty, and a valid criminal law purpose. And before getting even to that test, there's a first question which a court will ask itself in constitutional litigation, which is in fact often determinative of the litigation. And that is, what are these regulations really concerned about? Or to use the constitutional jargon, what is the pith and substance of these regulations? So for example, are these regulations truly aimed at prohibiting behavior that will cause the serious and existential harm of climate change? Or rather, are they aimed at regulating one sector based on federal policy preferences? And the court will look to context as well as the regulations themselves in addressing that question. So just to provide an example, if the regulatory impact analysis statement emphasizes the serious harms the regulations are intended to address, that is helpful. And on the other hand, if the regulations were to contain a lot of exemptions or rules that aren't explainable with respect to the underlying criminal law purpose, but instead just seem to reflect policy preferences, that could be an issue. That could be suggesting that this is just, the province trying to engage itself in regulation that should be provincial. So the first question in the criminal law test, does the scheme contain prohibitions backed up by penalties? This is perhaps the easiest part of the test to satisfy. Complex regulatory regimes have been upheld as criminal law. However, it is important that the scheme's core prohibitions are focused on preventing greenhouse gas emissions. There was an interesting discussion on whether the federal carbon pricing legislation could be upheld under the criminal law power in the decision of the Saskatchewan Court of Appeal. And the court found not, because it found that the carbon pricing scheme was not aimed at prohibiting greenhouse gases, but greenhouse gas emissions, but rather incentivizing the good behavior of producing less greenhouse gas emissions by requiring the payment of a fuel charge. So this may be a fine point of legal drafting, but I'm sure the federal government will be looking at that in drafting the oil and gas emissions cap regulations. And finally, I could have flipped these aspects of the test, but anyway, for the purposes of the slide, does the scheme have a valid criminal law purpose? So it's already been established that environmental protection, as well as greenhouse gas emissions reductions, are valid criminal law purposes. Hydro-Quebec spoke to environment, Syncrude spoke to GHG specifically. But that said, because the criminal law test doesn't explicitly provide for considerations relating to the balance of powers, the Supreme Court has been becoming stricter in recent years and in its assessment of whether there's a valid criminal law purpose. So some members of the court are increasingly looking for evidence from Canada that it is operating pursuant to a criminal law purpose. And so Canada will want to make sure there's evidence demonstrating that the specific threats that the clean electricity regulations, that the oil and gas emissions cap are intended to address are well-defined and real. So I'm going to pretty much wrap up my presentation here. Just briefly, again, on carbon pricing, the federal carbon pricing regime was upheld in 2020 by the Supreme Court of Canada. It's constitutionally safe for now, but I just also want to note that the Supreme Court set out a stringent test for finding a matter to be of national concern. So the applicability of that decision, it's still good law, but its applicability is relatively limited to other contexts. And of course, the IEA, that's the most effective. We've already heard from Dave about that, so I won't speak further about that. And that's it from me.
Thank you all for those insightful presentations. It's a lot of information. Just a reminder, we will be circulating the recording after if you need to refer to anything again as a refresher. And I've pasted, I think, both of the blog links in the chat as well. So now we have about half an hour for a discussion and questions. You are welcome to ask your questions in the Q&A or in the chat. And we did also have some questions that came in during registration. So why don't we start with some of those while others are entering their questions now. So one of the questions we received in advance was, what do you think the concrete impacts of the opinion could be on how climate-related criteria are interpreted in relation to the public interest determination?
I can start. I think, yeah. So good question. I would say for the moment that is mostly off the table, if not entirely off the table. And so, given that the Supreme Court rather did not extend its logic or really engage meaningfully with the argument that climate change impacts on areas of federal jurisdiction, that is off the table. So again, the court basically said, look, when it comes to decision making, this must be funneled back to the federal heads of power that are essentially underpinning the assessment process underway with respect to that specific project. So think fisheries, think navigation, think well-being of Indigenous peoples, and so on. Having said that, it's an open question. And so we're going to see what the federal government does in terms of amendments to keep greenhouse gas emissions in there. And then it wouldn't be in the amendments, but presumably with the package of amendments, the federal government would be presenting a robust legal argument to say, here it is. here's our legal footing, let's go. And one thing we can chat about is, whether or not there might be a second reference case, as there was in the securities reference case, just to get more legal clarity, even if that's politically shaky.
Can I maybe jump in, and Dave and Anna, I'd be keen to hear your thoughts on this too. I am inclined to think that there may be one avenue that is currently open to the federal government. And as you'll know, the strategic assessment of climate change allows proponents to claim the net GHG benefits of a project. So for example, an LNG export facility that the proponent claims will be used to displace coal in another country, or there could be domestic benefits claimed here in Canada. I think that may open the door to a net GHG analysis that the federal government could do. So in other words, if the proponent doesn't claim anything about GHG benefits, then, maybe the public interest determination has to be limited in scope now. But so long as that door is open, then it would be open to decision makers to then weigh the claims of GHG, net GHG benefits against competing evidence and look at the net GHG issue as a whole.
Yeah, I love it. Trying to find any loophole here. The only thing I was gonna add was that flag that it is now open to proponents to make that positive contribution to GHG's argument. But yes, interesting to think about whether that can somehow also get a consideration of the adverse harms.
So great point. I think what that does, it's tenuous all the way through, right? It's a dubious assertion that Canadian LNG displaces emissions abroad, that there are various opinions on that. The analysis is ongoing, but there's lots to say that that's not the case. And you all know that. Furthermore, this really lays bare how wild it is to put a thumb on the scale of only considering non-federal benefits and not adverse effects. And I know a lot of us are still scratching our heads on that and wondering if the court really understood the implications of that thumb on the scale conclusion that they reached. But you're not wrong, Anna. And again, the other thing to keep in mind here is court's narrow treatment of the presumption of constitutionality notwithstanding. The whole regime, including the guidance, was really set up for a proponent to showcase how well they're doing on greenhouse gas emissions, and the fact that downstream emissions are not in, and that displacement of emissions internationally was in, already put the thumb on the scale. But that part likely has not changed, as you say.
So another question that we received in advance, I know you just mentioned LNG briefly there. What are the specific implications of the decision for LNG projects?
You want to start that one off, Anna?
There's two of us, but Anna J can go first.
Ambiguity.
Well, maybe less so than other project types, because as export and shipping projects, LNG facilities are actually regulated by the federal government. So one of the things that we didn't have time to really get into detail in our presentations is that the majority did say that, so, projects have an activity, and then they also often have a resource component. And where the activity is regulated by the provinces, then federal decision-making is more limited and really has to just be focused on the impacts on the resource, like fisheries. But where the federal government is the regulator of the activity, so for example, the export of LNG and marine shipping, then it does have much broader latitude to scope in, non-federal adverse effects. And so I would need more time to really chew this one over, but my preliminary take is that with LNG, probably there still is the jurisdiction for the federal government to consider climate impacts.
Second, Anna? Yeah.
Okay, thanks. So maybe the two of you can help also clarify something. But my understanding is that a lot of LNG projects are currently undergoing substituted assessments. Like the primary regime is the BC regime anyway. So maybe in that regard, the impact isn't as serious as for some other projects, because the BC government, as I understand it, does have an amended EA regime that does involve quite, rather comprehensive assessment of greenhouse gas emissions, with some big exceptions, no downstream emissions. I'm based in Alberta, but anyway, those are some thoughts on my end.
Yes and no. So as Dave pointed out, the court did say that the feds can consider anything they want in the scope of, like, in the actual assessment, they can gather all the information they want. In the substituted assessments in BC, the federal government retains its own decision-making power. And so the question is, can the feds consider climate when making the public interest decision about LNG? And substitution doesn't really affect that. So I think the question is just, for me, how the project is scoped. So if it's scoped to include the marine shipping and the export, then we have federal authority over the activity and the ability to then consider the wide range of factors in making the public interest decision.
Yeah, no, point 100% taken. I think just to clarify, one of the implications possibly from this Supreme Court decision is, the importance not to forget that we do have the provinces and as well as the federal government, right? So we need to work on both of those sides of the spectrum. And so this, maybe in BC, this also points to the important role of the BC government in their assessments as well.
Yeah, I would agree with all that. I mean, the starting point would be to confirm and clarify the extent to which any activity is a federally regulated activity, and to the extent that any given LNG project is, then the constitutional fettering is minimal. And so where LNG is interesting is it's not quite as clear as, say, offshore oil and gas or interprovincial pipelines. But I find it hard to think of an LNG project that is not heavily federally regulated, and hence federally regulated activities. And so just to actually zoom out for a second, it's important. Probably most folks on the webinar recognize this, but when we're talking about the designated projects aspect of the IA being ruled unconstitutional, the important follow-on there is in its present form. So the designated projects regime with the planning phase and the triggering, all that is actually constitutionally structured. That architecture that started in SIA 2012 is fine. It's just in its present form. And so what we're mostly talking about here is how to shift that form so that it conforms with the majority opinion. And I think that's a really important distinction to make. So when it comes to things like potentially LNG projects, but especially interprovincial pipelines, offshore oil and gas, the designated project regime is fine. The entire act is fine. It's not unconstitutional. So it really is for, if you think, as Anna said, 10 to 12 projects a year, it's the ones of those that are not clearly federally regulated where this gets interesting. So when you look at sort of the report card of where this decision lands, I keep saying it to folks, it's not like, 10% out of 100 is not an utter failure. We're in like the 49 to 51% range. And that's why people are saying that it only requires tweaks to bring it into conformity with the majority opinion.
Thanks. Great discussion. So another question here is, what happens to ongoing IA projects that are not on federal lands, for example, Highway 413? Can the proponent, for example, the government of Ontario, now force the government of Canada to undesignate these projects?
So yeah, this is a $1 million question. As I mentioned in my presentation, in my opinion, the act still stands, and projects that were brought in to the hopper have to stay in the hopper. The Ontario government has brought a legal challenge to the minister's designation of Highway 413, and so we'll see what the court has to say about that designation. But so long as when the agency reviews assessments that are currently underway, which it has said it will do under the interim guidance, so long as it does find that, yes, indeed, there is that federal jurisdictional hook for the designation, then those projects like Highway 413 should remain in the process. In my view, the big question is whether or not the federal government intends to enforce its own rules. So if a proponent decides to opt out, will the federal government enforce the provisions under the act that, impose fines and sanctions on proponents for not complying with the act? That's maybe less of a legal question and more of a political question.
Yeah, I made the mistake of reading the chat while you were speaking, Anna Johnston, but I think I caught it because Jillian's question in the chat was really interesting. But on this one, I mean, I think what you could see is an application for judicial review saying that this was wrongfully designated, and the federal government would be wise to get ahead of even a JR. And presumably some of the work that's happening in Ottawa right now on both sides of the river is clarifying the federal constitutional basis for each of the projects that have been designated, and with an emphasis on those that may be perceived as thin ice like this road. But when you think of a road like 413, I don't know that project extremely well, but think of wetlands, fisheries, navigation, and so on. You have those robust enumerated heads of power. So it wouldn't be hard to just write that argument up and present it to the proponent. And if they disagree, then they might choose to waste their money by applying for judicial review.
Thanks. Why don't we go to that question in the chat that you mentioned, David, from Jillian. An LNG project is being developed by the Haisla Nation. Can you define how this project will be assessed given Fed's responsibility over First Nations and the intersection of well-being of First Nations and greenhouse gas emissions?
Yeah, so I think that's a great question. That specific project was actually in my mind when we were chatting about LNG projects a few moments ago, and so I would view that as a project that is heavily federally regulated. And so the constitutional constraints that we're talking about, I don't think would apply to that project. But the federal government would, especially in terms of triggering. But when it comes to decision making, what the federal government would have to be careful to do is to carefully explain how the decision is linked to those federal heads of power and how any significant adverse environmental effects, what they look like with respect to federal areas of authority. And then the question will become, are those justified in the circumstances, assuming the amendments start to look like a 2012 amendments. So I think that's how that would shake out. And in practice, it would probably shake out similar to Cedar LNG, subject to the post-Cedar LNG BC net zero credible plan rules that are now in place. But I expect that they can pass muster on that front too.
All right. Well, we've got some more questions coming into the Q&A right now. So one here from Chris, seems like this needing to rationalize public interest decisions to just benefits and costs that are federal in jurisdiction silos the public interest decision when public interest knows no jurisdictional boundaries. But maybe I misunderstood.
Yes. Chris, you have put your finger on what I and others have identified as the real problem with the majority's opinion here, is it creates this artificial bifurcation in the Constitution between what's a benefit and what's an impact. And it essentially, in my view, I think, will have the effect of forcing federal decisions to go back into the black box if they want to be made in a fully informed manner. And I'll point out the fact that the Impact Assessment Act is the first regime to require detailed reasons for decision. And so before it, under SIA 2012, the majority said that decision function, which was whether significant adverse federal effects were justified in the circumstances, was an okay decision, but in the circumstances was totally undefined. And so what the federal government did and did not consider was anybody's guess. And what the court is effectively suggesting Canada do is, first of all, put on some blinkers and think in this siloed approach without looking at the full implications of its decisions. But then also, if it does want to look at the full implications of its decisions, that it just do so in a totally untransparent way, which, in my view, is not good for the provinces, for Canada, or for the environment.
Yeah, I mean, I think one way to read the majority opinion is as a step backward in transparency and decision making, which is unfortunate, especially given the architecture is kind of premised on democratic accountability. Although the intact assessment phase means that all that information can get out there, and there is still sort of a democratic accountability court of public opinion dimension there, right? So on climate change, for example, if a high emissions project is required to explain scope 1, 2, 3 emissions openly and rigorously, and the public is able to see, whoa, you know, I don't see how this fits with Canada's climate commitments. The federal government might still approve that, but at least the information's out there. And so to the extent that IAA impact assessment has these two personalities, information gathering and decision making, the information gathering dimension is still intact and arguably more important than ever. But I think, you know, Chris, it's a great question. And I know you and I have chatted about cost benefit analysis in the past, but I think there's two main ways to try to interpret the majority opinion. One is that when you're looking at the adverse effects on areas of federal jurisdiction, that is packed into this sort of asymmetrical analysis of burdens and benefits. You've got unfettered ability to take into account benefits and a fettered ability to take into account burdens. That's one way, and that's kind of the more disconcerting and frankly close to illogical way, or at least counterintuitive way. But the other way is to actually have a robust, holistic, comprehensive assessment of benefits and burdens, see where it lands, and then run that through the single axis of federal authority. So take a look at what that looks like in terms of burdens and benefits, and then relate it to fisheries, navigation, and other areas of federal jurisdiction. I'm not sure the latter is constitutionally permissible. It seems at this point, a lot of us are still thinking like a reasonable interpretation because it does what the court says, funnels it back to areas of federal jurisdiction. But are you then regulating the project qua project, which seems to be the court's concern? And maybe you are, but one of the beauties of impact assessment, if you're a proponent, is it allows you to say, look, we're going to harm the fish habitat and navigation. And I know you don't like that. I know you have the power to say no, federal government, clearly. But look at all the good stuff we're doing. And so, again, it's still unclear how that constitutional dimension is going to shake out.
That was super well stated. I don't have anything to add.
Thanks, all.
And I think maybe that answers the second question in the Q&A around the strategic assessment of climate and how it can be considered in decision making. It's, as Dave said it, there's still a lot of value in bringing that information to light during an assessment, even if the federal government's ability to consider it in decision making is more limited.
Yeah, and that's all assuming no strong POG argument is brought forward and anointed by the courts, right? And all assuming that the option 2 go big approach of yes, climate impacts are impacts on areas of federal jurisdiction does not have legs. So, you know, it could be that we get clarity and none of this is problematic, but right now we're in the dark.
I just want to recognize that I think this question is a good one, though. It's definitely something I'm grappling with as well. Like what the Supreme Court says about the assessment phase just doesn't jive very clearly with what it says about decision making. So I think it's a good question to be asking at the same time.
Thanks. Okay, we'll go to the next question from Ken. How can federal decisions on greenhouse gas emissions leading to impacts on provincially regulated oil and energy worker pension plans be considered to not have a constitutional impact on their implementation? The pension funds depend on constant contribution, and cut in greenhouse gas emissions can cause their collapse. Would judges consider that in a constitutional case?
So if I understand the question correctly, I mean, I think a judge would consider that, you know, if we're talking about a pension plan for employees of provincially regulated undertakings, then it comes back to whether or not that could be information gathered in an assessment, but a federal authority would be more limited in being able to consider that information when they're making a decision because it is about the provincial activity. It's about an area of provincial jurisdiction.
Yeah, I could just hop in. I mean, I think it's a good question, and that's what's important to keep in mind here. I mean, these are for the high emissions projects that are right at the margin here, and to be clear, there are very few. You know, the Act was set up to approve almost all projects, notwithstanding the Cold Spur Mines letter and the Suncor Base Mine Extension letter. And so I think the way to think of this in constitutional jurisdictional terms is that would fall within provincial jurisdiction over property and civil rights and natural resources. And that's what the court was really concerned with here, was an imbalance in the division of power such that the federal government was using narrowheads of power to overstep or to imbalance the division of powers between the provinces and federal government. So I think you see that concern reflected in the majority opinion very much.
Okay, up to the next question. For projects that are in the hopper and not fully federal, does the provincial legislation now take precedent, for example, on LNG projects? I'm not sure if that was already answered.
But I mean, I think it's worth reiterating so that no, I don't think so. And it's really important to note that the court explicitly said that just because the provinces are the primary regulator of the activity doesn't create what they call an enclave of exclusivity. So in other words, just because an activity might be regulated by the province, that doesn't prevent or prohibit the federal government from playing an active role in the regulation of the impacts on areas of federal jurisdiction. So there's no, one takes precedence over the other. The federal government can still say no to impacts on areas of federal jurisdiction. It can't regulate the provincial aspects of projects, but it still can regulate all of the federal aspects of them. So, for LNG, again, a lot of those activities actually will be federally regulated, but for the activities that are provincially regulated, there's still a strong federal role in assessing and saying no to, or yes, of course, to the effects on areas of federal jurisdiction. So it's not a one trumps the other. They both have strong, both provincial and federal governments can still play strong roles, just so long as they're actually focusing their decisions on the areas that they have constitutional authority to regulate.
I have a thought too, but Anna M, do you want to go first? You good?
I'm good on this one.
Okay. I mean, I think the way to think of it is for these major projects, there's provincial jurisdiction, federal jurisdiction, both, it's clear, can legislate EA laws. And so even though there's this holy grail that's often talked about in terms of one project, one assessment, there's still always two approvals. And so for an LNG project, you're looking at a proponent trying to get two green lights, if you will. But for some projects where the federal government does not have jurisdiction, it is the provincial regime that is primary, if not the only one for decision-making purposes. So it's a single green light. But that's going to vary on a project by project basis. An elephant in this room is the extent to which we all think that the provinces are doing a good job of comprehensive assessment and decision making with respect to these projects. And so one fallout of the majority opinion at present is that provincial regimes are more important than ever. And to the extent that they are outdated or not great at what they're supposed to be doing, we have gaps in the law. And that's a reality that that story, I should say, that story is being written based on whatever amendments the federal government comes forward with.
Thanks, David. So the next question from Gretchen: for offshore oil and gas, where major expansion is planned by Newfoundland, how do you think GHG emissions will be considered under the Impact Assessment Act? Scope 1, 2, and 3.
Go ahead.
Yeah. Okay, I'm happy to start off. So offshore oil projects are projects within federal jurisdiction. So that is a kind of carve out to the Supreme Court's otherwise very unhelpful reasons on decision making, where as far as the Supreme Court is concerned, the federal government can consider what it wants in assessing and in approving projects that are primarily within its jurisdiction. So I think, something for me that'll be interesting to see is what IA amendments will be introduced as far as those projects that do fall primarily within federal jurisdiction. Is there, with respect to downstream emissions, I think currently we're in the same situation. Maybe there's an opportunity to lobby, maybe not. But in any event, there's definitely much more constitutional leeway with respect to such projects.
Yeah, I would just say the guidance is what the guidance is, and Gretchen, that probably won't change because they're federally regulated projects. So I think you can proceed on the basis that the existing guidance is still good guidance, unless the government takes the view that, okay, you've taken away some of our decision-making power, we're going to double down on the assessment phase and require even more, i.e. Scope 3 emissions. But I think that's probably a long shot.
Thanks. All right. We have time for a couple more questions, I think. And the next one is, do you think it would be possible for Canada to shift from POG to the criminal law power applied specifically to the IAA? Or does the government need to look bigger for GHGs and have those results eventually trickle down to Impact Assessment Act?
It's a great question, and I think we all have thoughts on it. I think, a lot of people are putting their mind to whether that's possible. And there may be two ways that could be done. One is advancing a criminal law argument with respect to the IAA itself, which is what Ecojustice did in the Supreme Court case. There's certain downsides to that argument, including that the IAA is a very discretionary regime. Criminal law is much more focused on prohibitions. But I know there's also discussions being had about whether existing criminal law regulations, such as some of the regulations that I discussed in my presentation, whether certain that existing jurisdiction, including the possibility of even adding permits to that regulation, could create the possibility of a trigger more along the lines of the CA 1992 regime, with where there's an external, where there's a lawless trigger, the fact that there's already a regulation upheld under the criminal law, if that could create certain impact assessment jurisdiction. So complicated issues, but I think there's definitely some thinking to be done on that. And Anna and Dave, you may have thoughts too.
No, I think go ahead.
Yeah,
Anna.
I think you've captured it well.
All right, one more question before we wrap up from Keith. The project list was up for review. How does the SCC ruling affect that?
Maybe I'll jump in on that one. I think it helps it quite a bit. The majority, as I mentioned in my presentation, says you only need a low jurisdictional threshold to designate projects. So we have heard that the federal government is going to look at amendments and the project list review together in the same light. So what they actually decide to act on is another question. But legally, I think the majority opinion gives the federal government pretty wide latitude to considerably expand the project list, so long as the projects that are on the list do have the potential for adverse effects within areas of federal jurisdiction. And then so long as, once an assessment has started, that initial screening decision that the agency does in the first couple of months, primarily focuses on the potential for federal effects. I think so long as you have those two things, the majority of opinion gives Canada quite broad cover to significantly expand the list, because we know that under the original Canadian Environmental Assessment Act, it triggered, thousands of assessments of projects that affected areas of federal jurisdiction a year.
I would agree. I mean, this is where the court's upholding of the designated project approach is really helpful. And then they clarify that the threshold is low to get on there. And so in putting together that project list, the federal government 5 or so years ago was constitutionally timid, and also, cognizant of striking the balance based on input from industry at the time, like it or not. And so it could be expanded in this context. The one lingering area of uncertainty, though, is the extent to which impacts of greenhouse gas emissions may serve as basically the entire basis for anything on the list. And again, this is where the court leaves the door open with some clarity. And so that's really helpful, because the government can now see the case it needs to meet, essentially, to include a climate trigger, as it's been referred to in the past. And so ball is very much in the federal government court with a lot of spin on it.
Great. All right. Well, I think that is about all the time we have for questions today. Thank you so much for this really thoughtful discussion and for all the questions. And special thanks to all our presenters, Anna, David, and Anna, for sharing your expert insights. I'll pop a few links in the chat here for our websites where you can find more information, and we'll be following up in the next few days with an email with the recording and also the links to those 2 blog posts we shared earlier. So yeah, keep an eye out in the next few months. I'm sure we'll all be watching closely what happens with the Impact Assessment Act and progress on major climate policies. So yeah, thanks again for joining us, and have a great day.
Thanks all.